Hey everyone, it's B with 2B Fruitful Training Group. All praises to the Most High. And today we're going to be going over the doctrine of incorporation by reference, where it's applied, where it's been established, and where it really originated from. So, the doctrine of incorporation by reference under the law of wills means that unattested papers not present when the will was executed, can still be regarded as part of the will by incorporation. A writing that is not valid as a will, but is in existence when a will is executed, may be incorporated by reference into the will if the will manifests an intent to incorporate the writing and the writing to be incorporated is identified with reasonable certainty. In Advanced Display Systems of Incorporated versus Kent State University, 212 F 3D 1272, the Fifth Circuit held that incorporation by reference provides a method for integrating material from various documents into a host document by citing such material in a manner that makes it clear that the material is effectively part of the host document as if it were explicitly contained therein. To incorporate material by reference, the host document must identify with detailed particularity what specific material it incorporates and clearly indicate where that material is found in the various documents. See Uniform Probate Code. So this stemmed from the law of wills. And before we go any further, I'd like to point out this is all under fair use for the purposes of teaching, commenting, training, and educational purposes in a classroom setting. So what we have here is the Fordham Law Review. This is Volume 29, Issue 1, Article 4 from 1960. Incorporation by reference and independent legal significance in the New York Law of Wills. So I'm not going to read the whole document. You can check that out for yourself. It has a very clear distinction in what is and isn't allowed. The main distinction being whether the incorporated document has independent legal significance, meaning whether it's just unattested papers that are not established in law already versus an already existing agreement, trust, similar readily recognized entity, something of that nature. But what I want to go over in this particular part right here, it says, still later, however, the court decided in the matter of Roush, which is said to stand for the proposition that New York recognizes incorporation to a limited extent. There, the testator bequeathed a part of the residuary estate in trust. So the residuary estate is the remainder of the estate after the debts and duties have been taken out and satisfied, for the benefit of his daughter, quote, under the same terms and conditions embodied in the trust agreement, made between myself and the said New York Trust Company, end quote. The will contained words expressly incorporating the existing trust agreement. The bequest of the inter vivos trust was upheld by the court, but the reasoning was not all clear. It is evident from the facts of the case that the requirements of incorporation were satisfied. The trust was inexistent at the time of the will. It was clearly referable as the trust to be incorporated, and there was an express intention to incorporate it. Yet some commentators doubt that the decision was based on incorporation. The court observed that quite often it is necessary to resort to factors extrinsic to the four corners of the will. Quote, here the extrinsic fact, identifying and explaining the gift already made, is as impersonal and enduring as the inscription on a monument, end quote. To this extent, it is clear that the court was thinking in terms of independent significance. On the other hand, in comparing the facts of the case with Hathaway versus Smith, and distinguishing the latter on the ground that Hathaway's will and trust were executed simultaneously, the court was concerned with the time element, which is pertinent only in incorporation. These three leading cases have a strong doubt as to whether New York does in reality adhere to the common law doctrine of incorporation, even where inter vivos trusts or wills are involved. Each of the cases is sustainable on some other ground, and the alternate ground explains the case more adequately. Each is within the purview of the concept of independent legal significance. So the other examples in this Fordham Law Review go into cases where the testator was not able to successfully incorporate by reference certain other papers, because whether they be in the order in which they were executed, meaning the documents were not in existence at the time of the will, or they were simply considered unattested memoranda before the court, meaning they had not been proven or proved up, or some other method of legal significance to estate planning, like trusts, inter vivos trusts, express trusts, etc. So that was one of the biggest differences in this law review. So going into other places where the doctrine of incorporation by reference is noted or accepted or established is the Federal Rules of Civil Procedure, Rule 10, Form of Pleadings. And it says, A, caption, name of subparties. Every pleading shall contain a caption setting forth the name of the court, the title of the action, the file number, and a designation as in Rule 7A. In the complaint, the title of the action shall include the names of the parties, of all the parties, but in other pleadings it is sufficient to state the name of the first party on each side with an appropriate indication of other parties. Paragraphs, separate statements, all variants of claim or defense shall be made in numbered paragraphs, the contents of each which shall be limited as far as practicable to a statement of a single set of circumstances, and a paragraph may be referred to by number in all succeeding pleadings. Each claim founded upon a separate transaction or occurrence, and each defense other than denial shall be stated in a separate count or defense whenever a separation facilitates the clear presentation of the matter set forth. C. Adoption by reference. Exhibits. Statements in a pleading may be adopted by reference in a different part of the same pleading, or in another pleading, or in any motion. A copy of any written instrument which is an exhibit to a pleading is a part thereof for all purposes. So here, it's incorporating by reference through the term adoption by reference. The incorporation, the common law incorporation through which you can include other documents that are completely separate, yet also in their own capacity, bystanding documents. So you can, let's say you have a Schedule A in trust. You can then take the title of, the valid controlling title to some particular piece of property, a document, bonds, notes, whatever disposal that you have, right of disposition for the property. You can go ahead and then incorporate that into a trust. Again, it's important to remember that every case is a trust. So this is something that's very well recognized in the law of wills. But just like the Fordham Law Review said, it depends mainly on the document being in existence at the time of incorporation by reference. So you can't reference a document that's not been created. So you have to have the document, or whatever it is, in existence. Then you incorporate it into the trust through incorporation by reference. So here, out of Black's Law 2nd edition, we have case defined. It says a general term for an action, cause, suit, or controversy at law or in equity, a question contested before a court of justice, an aggregate of facts which furnishes occasion for the exercise of the jurisdiction of a court of justice. Smith versus Waterbury, Kundolf versus Thalheimer, Gebhard versus Sadler, Iowa 156. And further, out of Anderson's Law Dictionary 1889, we have action, doing a thing, the exercise of power, physical or legal. The thing itself as done, an act as legislative, judicial, executive action. 2. The lawful demand of one's rights in a court of justice. an abstract legal right in one person to prosecute another in a court of justice. A suit is the actual prosecution of that right. And again, out of Corpus Juris Secundum, Book 90 on trusts, out of subsection 1, we have the definition. It says a trust is defined as the right enforceable solely in equity to the beneficial enjoyment of property, the legal title to which is vested in another. But the word trust also is frequently employed to indicate duties, relations, and responsibilities that are not strictly technical trusts. So again, it is defined as the right, which is enforceable solely in equity. So what is somebody doing when they're coming into court? They're making a claim. They're demanding certain performance. They're seeking some type of relief to be ordered by the court against the defendant. So again, cases are trusts. So this is something to be aware of in the future. And if you found this video helpful, please consider supporting 2Be Fruitful Training Group. Cashapp is BL2Be Fruitful. Thank y'all for watching this video, and I'll see you in the next one.